Hi everyone, Derek Johnson with Tatango.com. I'm here at Innovista Law, which is home to the TCPA Defense Force. I'm with Joe Bowser here, TCPA attorney. So Joe, what happens if you violate the Telephone Consumer Protection Act and someone threatens to sue your business for violating the Telephone Consumer Protection Act? And I guess maybe there's two, maybe if you maybe are in the wrong or if you know you're not in the wrong.
Right. Well, a lot of times you're not.
Okay.
Right? Because every day our clients get demand letters saying, I didn't consent to get these calls. You've called me 100 times. I'll settle quickly if you cut me a check of X dollars.
And this is not a lawsuit they're filing.
It's a demand letter.
Okay, so it hasn't reached the court yet. This is just like FedEx to you or the brand, and it's a threat.
Exactly.
Okay.
Right. It has no legal consequence other than what we're about to talk about.
Okay.
So when you get a letter like that, courts think that you ought to start preserving the evidence.
Okay.
And so you should. So you send out what's called a litigation hold notice about that consumer. A lot of times you don't necessarily even get their phone number.
I've heard that before.
They'll make demands and say, you called me without my consent, and not give their phone number.
Okay.
Well, that's interesting. Would you like to tell me your phone number?
Yeah.
So I can look this up? But in any event, so there may be back and forth between the consumer and the company.
Now, should that be, at that point, should it be handed off to corporate counsel or TCPA attorneys? Who is handling that communication?
Right. Well, so we'll get into some of the risk mitigation
Okay.
issues, but legal should definitely be involved.
Okay.
Right? Whether if you have in-house counsel, certainly get them on board.
So this is not the marketing person.
No.
At that point, get some attorney involved.
TCPA exposure is real.
Okay.
And it's 7-figure and up for any real campaign.
Okay.
So you definitely want legal involved. Risk management may need to be involved because you probably want to look at your insurance policies
Okay.
to see what coverage might exist. So you want to preserve your evidence.
Okay.
You want to gather that evidence because the best form of defense is consent.
What do you mean by preserve the evidence?
So
Sounds like a crime scene.
No. So if your call logs would ordinarily get recycled,
Okay.
you want to suspend that recycling function.
Okay. Just
right?
make sure you're not throwing things out and getting rid of
Exactly.
records.
So what you don't want to happen is for things that are currently accessible.
Okay.
Right. You could go dip those logs real quick, right?
Yep.
You don't want them to get put on backup tapes that aren't labeled well, that are only really for disaster recovery
especially
purposes.
after you get the letter, because then that just looks bad.
Well, not only does it look bad, it can carry legal consequences about the spoliation of evidence.
Okay, so really preserving the evidence is not like a crime scene. It's essentially making sure all the data remains intact that was there and present when you got that letter.
Exactly.
Okay.
And you want it too, right? You want to be able to access it.
Yeah.
Because like I just said, your best defense may be consent.
Okay.
And it's a defense that you have to prove. So they just have to say, I got an unwanted call via an auto dialer or unwanted text via
Yep.
an auto dialer, period. That is a TCPA violation.
And you as a business now have to defend yourself.
Exactly.
Okay. I think we talked on an earlier video about keeping records.
Mm-hmm.
And it seems like at this point, I think it was 4 years or something, but also that doesn't include when they opted in and all the records back then. It sounds like just keep all your records and make sure they're in good order as well.
Right. Yeah, exactly. If they're not searchable,
Yeah.
they're not doing you any good, right?
Yeah.
Then you can't mount your defense.
And records include like inbound, outbound text messages, any ads you're running, even television ads. Would you keep in like a copy of the television ad?
Exactly, because they could say that they revoked consent in an inbound message. It might be tempting to say, well, I don't care what they say to me.
Yep.
Well, if they say, I texted you to stop texting me, you want to be able to comb your
all
records, sort it by their phone number, and be able to say, well, these are the messages we got.
So
you're saying
really-
I magically lost the
Yeah.
one that you...
Every single text message, because I know some providers are like, oh, we keep all of the outbound text messages. Keep the inbound, keep the outbound, keep everything. Even when they text in mistakes or something that doesn't match anything in your system,
Well,
keep it all.
If there ever becomes a question about the integrity of your records,
Yeah.
if you have everything, you don't have to talk about gaps,
Okay, perfect.
right? So, so you want to preserve the evidence.
Okay.
You want to go through that evidence to find out what evidence of consent you have.
If I guess you can, because they might not give you the phone number, right?
Correct.
Okay, so first you got to get the phone number and then be able to search through the evidence.
You might be able to cross-reference your data. You might be able to go back to your client or
Okay.
cross-reference them in some other way to say, all right, his name is Jimmy Johnson.
Okay.
I've got a Jimmy Johnson here in my files. I don't know his phone number, but I only have one.
Yep.
Let's take him out of the campaign.
Okay.
Let's stop texting him now, right? Because what you
that
want
would be stop text messaging them.
right. So you
Okay.
should treat that letter as a revocation of consent.
Oh, okay. I
Right.
didn't know that.
Yeah, it's a best practice.
Yeah.
The guy's gearing up.
He doesn't
to sue.
want, stop text messaging him.
Yeah. So if he's telling you in that letter, you sent me a message or one or more messages without my consent, I would read that letter to say,
As removed.
if I haven't already, I'm revoking consent.
Okay, that's good. So conserve all the records, then remove that phone number if it's included, or try to find that phone number or the phone numbers. So any other steps?
So you want to, so you put the litigation hold on, you preserve the evidence, you go through the evidence to find consent,
Okay.
you let legal know, of course,
Yep.
and then you start preparing your defensive letter, right? If you have evidence of consent, you want to get that out there, right?
Okay.
Because that'll put the 9 out of 10 plaintiffs' attorneys on their heels. They've got a number of other cases going. They've got a pipeline of cases that they're trying to pursue. If they see that you have clear defenses, they'll walk.
It's not worth it for them when there's easier cases, you're saying?
Exactly.
Okay.
Right.
Okay.
So you want to put them off, right? So
Okay.
there's no reason to say, oh, we'll prove it later.
Yep. And again, attorneys should be doing this, not the marketing manager.
Well, right. The attorneys want to do an appropriate investigation
Yep.
just to make sure that there's nothing squirrely in there.
Yeah. But
Right.
I mean, the letter back to their attorney should come from, because I know some marketing managers might go, oh, I got this.
Mm-hmm.
I'll respond back and say, no, you opted in here. That should always be passed off to counsel.
Exactly.
Yeah, okay.
Right.
Okay.
Exactly. Particularly if they're sending the letter by counsel.
Yeah, okay.
Right.
Okay.
And then you want to get the insurance company involved if there's a chance for coverage.
Okay.
Right?
So if there
Because-
might be an issue, that's when you
Right,
involve
so
insurance.
because some insurance policies are so-called claims-made policies,
Okay.
and they require timely notice.
Oh, okay.
So you don't want to wait to see how the letter writing campaign shakes out, because if you miss the deadline to put them on notice and there was coverage, you risk losing that coverage.
Interesting.
Just because, I'll just wait until they file a complaint.
Yeah, and that could be a year later, and now you have a problem with your insurance company.
Exactly, because the TCPA gives the plaintiff 4 years to file.
Okay.
So they might send a letter, and some of these professional plaintiffs send
a lot of letters.
A lot of letters, right?
Yep.
They have a lot of phones, they have call logs.
Yep.
They're just dashing these off, right? So they may not get around to suing you. I've had clients that get sued 2 years later.
Oh, wow. Okay.
So you don't want to not tell your insurance company because it hasn't materialized.
Yep.
Some people think, well, I don't want to tell them because it's going to hit my claim history.
Yep. Well, that's not worth it if there would be a claim in the future and they
Exact-
wouldn't defend you.
Well, right. There's a misimpression about the extent to which just putting your carrier on notice actually affects the claim history.
Okay.
And the extent to which it hits the premium.
Okay.
Right.
It affects how much you're paying for insurance. Okay.
Right. If your premium goes up $1, is it worth preserving $1
Exactly.
million of coverage?
Yep.
I would think so.
Okay.
So, subject to crazy circumstances,
Yep.
I would put the carrier on notice, and then make sure that the people who may have access to those records know that the records are being preserved, and they shouldn't do anything to deviate from that preservation protocol.
Okay. Make sure everybody's on board.
Exactly.
Okay. So that include the marketing person, like, hey, don't delete any of this stuff.
Right.
This stuff needs to be preserved. Maybe even have backups of it
Right.
just to make sure.
Now, if you don't have evidence of consent, if this person has put the company on notice that, oh gosh, we may have had a campaign
Had a
that's
mistake,
not compliant, there was a mistake.
Yep.
You do want to circle the wagons, really quickly get a sense of what the exposure is, and stop any non-compliant campaigns as
Okay.
quickly as possible, right? Like,
So that wouldn't be a negative of fixing what the issue is.
no.
Okay. Because I think some people might be a little like, oh, I can't touch anything. If there's an issue with your system or issue with compliance, fix it.
Exactly.
Okay. Right away.
Right.
Okay.
Right. No, if there's a problem,
Yep.
letting it linger is only
Okay.
magnifying your damages, your
Makes sense.
exposure. And there are evidentiary rules surrounding the act of taking mitigating circumstances.
Okay.
Right? They don't want, if your pollution is going into the farmer's river and the animals are eating it, they don't want you to keep throwing the pollution in
Yeah.
just because that might be deemed an admission.
Okay. I think that was maybe the concern for some brands is, if we change it, that means we were in the wrong. But that's not the way to go about it.
You don't see the UPS driver
Yeah.
continuously ramming the person in the back of your end.
That makes sense.
That's just not a good idea.
Okay, so that's what to do if you are threatened to be sued by a, usually it comes from a attorney, right? This wouldn't be or I guess it could come from a consumer itself.
Yeah.
Okay, so it could be from an attorney or a consumer. Any other points up until they actually file a lawsuit, what you should be doing in terms of the threats that you would receive as a text message marketer?
I mean, those are the key things.
Okay, perfect. Well, that sounds good, and always consult attorneys. I always say that, because your SMS platform, your agency, most likely is not an expert in TCPA. We know enough, but not as much as some of these people. So, awesome. My name is Derek Johnson with Tatango.com. I'm with Joe Bowser from Innovista Law, and he is part of the TCPA Defense Force. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.